I want to welcome you back to the D-Lo Show. I am your host, Ryan D-Lo Delosier, and we're back for another episode today. I wanted to go back and cover the case that we went back to this one. This was a while ago. Actually started in November of 2019, but I wasn't covering it then. This is the Operation Nanny story. And I want to go back and just cover some of this case. The original one that I went over was the case against Frederick Walter Thomson. And in the time that, since I kind of had a little, I didn't record podcasts for a while. For a couple months right there that didn't happen. And during that time, Frederick Walter Thomson was sentenced. So he had gone through his arrest before. And he had gone through his trial and all that stuff. So I want to go over what the sentence was that went along with that. So we'll do that here. I want to go over that with you. So here we go. So going back to the story, the backstory on this of Operation Nanny. So it wasn't just an isolated arrest that happened. Fred wasn't just arrested all of a sudden for what happened. Frederick Walter Thomson was caught as part of a massive coordinated sting, which was referred to as Operation Nanny. It's similar to those cases that they had. If you were like me and didn't have much going on the evenings, you may have watched the show To Catch a Predator. So Chris Hansen would they would have this group of people who would call these unsuspecting future pedophiles, I guess we could call them that as well, and they would pretend to be an underage child, a child who is underage, or I guess they'd be just considered a child if they are under the age of 18. Except when they'd show up, the child wouldn't be there. It'd be Chris Hansen in the living room. Well, so similar to that, the Washington State Patrol did a similar thing, and the agency, what happened with this, there was a sting operation. It was executed here in Yakima in November of 2019, and it was led by the Washington State Patrol's Missing and Exploited Children's Task Force. Also working alongside with them was the federal and local law enforcement here in Yakima and Union Gap. And so during this sting operation where they did this, it resulted in 16 total arrests from around the region. And because of a heavy caseload that was going on here in Yakima County and continues to this day, a lot of these cases that I've talked about in the past, have taken a while to come to trial. As we talked about Teddy Lee Craven's last week in my last episode, how his is still pending and it's getting close. So I'll be updating you on that as well. But we're just going to stick to this one for right now. So local prosecutor later referred Thompson's case directly to the Washington Attorney General's office to handle the prosecution in this case. So that was the kind of the backstory of what went on with this. So what Washington State Patrol did was they set up a sting, and how this worked, how Thomson was caught, it's incredibly specific, and it provides a narrative for what we're going to be covering right here. So here's what they did. Okay, they had to get him to actually show up. So what happened was an undercover detective placed an advertisement on Craigslist, and this undercover detective posed as a mother. And in the ad, and also in subsequent text messages, the undercover mother claimed she was looking for an adult man to teach her daughters about sex. It was in quotes, wanted to teach her daughters about sex. A mother, yes, disgusting. And then she also explicitly offered up her children, whom she stated were 11 and 13 years old. Yes, so Fred responded to a Craigslist ad that was actually put on there. He thought it was a mom who was basically sending out her daughters. So he showed up to teach them the ways, I guess, of a 74-year-old man. Well, instead of there being 11 and 13-year-olds when Thomson showed up, when he responded to this ad, he explicitly confirmed his intentions over text messages. So he let them know exactly what he had intended to do. So there's the intent that goes along with that. And he arranged a specific time to meet the mother and the daughters at home. So he has the intent, he has this plan that he's going to go and do. And then when the 74-year-old arrived at the designated location, he was carrying condoms. He walked right into a house full of waiting law enforcement officers. So he had intent, he made a plan, and he also had the items necessary that were asked and agreed upon. So he had all these things that allows for the State Patrol to have probable cause to arrest him then and there. And so we had the sting context going along with that, and we have an order regarding exceptional sentence. So on April 29th of 2026, Thomson was technically communicating with an undercover cop. So he wasn't communicating with a minor. So there was no actual children at the house. So he was convicted of attempted child rape rather than like as if he had completed the crime. Okay, if there hadn't been a police officer there, he would have. So I guess that's fortunate for him. I don't know. But it's also fortunate that a child wasn't involved. Because he actively plotted to assault two different children, so the fictitious 11-year-old and the 13-year-old, matching, there's 2 counts in this case, the Attorney General's office successfully argued that his conduct warranted an aggravated exceptional penalty that's beyond standard state guidelines. So he actually got a little bit further sentence. And so the judge stacked the terms to ensure he received a maximum cap of life in prison. And that's what they do a lot of times in these cases. So they will they'll have he's actually has to be, and I'll continue with this here. So he has an indeterminate sentence. So he could be in there for life. Okay, and he's 74 years old, so that's that's really could be a probability, like a high probability of that happening. So and what he has to do is he's got to meet with the indeterminate sentence review board. And they're holding total control over whether he ever steps foot outside of his cell. So he's got to do 48 months, so 4 years after those are served, and then he can go from there. Now, and after that, this indeterminate sentence review board has the final say as to where he's at. So that's kind of what the wrap-up is there of Fred's sentence as he went through that. And during this case, though, on April 1st, funny, April Fool's Day, the clerk accidentally selected a drop-down menu that reads, case resolution, guilty plea before the trial commencement. So what happened right here, there was an error that happened in the case files that I had noticed when I was going through this. And I guess this is a common thing that happens. So in Washington State, county clerks use the Odyssey portal. This is where I find a lot of the stuff, and to manage all of these active files. And so when the case concludes, the clerk must close it out by selecting a case resolution code from the standard drop-down menu. So there's a menu right there, and they just click on it, and they're like, all right, this is where we're at with this case. Boom, push the button. Well, on April 1st, also known as April Fool's Day, the clerk had to log 3 massive things simultaneously. Okay, the first one, there was a formal felony judgment and sentence, that was signed by the judge. The second one was the entry of the exceptional sentence details. And the third one was the official case resolution status to move from an active to completed case right there. So because of the vast majority, roughly 90 to 95% of criminal cases resolve via plea, that we're going along with this, typically a lot of these cases, but instead Fred went to trial with his case. A lot of them get resolved via plea deal, but not this one. The clerk's fingers probably just defaulted to muscle memory, because most of the time, a case like this, when it's overwhelming, we're just going to go like, okay, we'll click the button that says guilty plea before trial commencement. Instead, what happened, he was actually guilty verdict by jury. That should have been what was clicked instead. So that's where we have an error in the notes that go along with this. In the legal world, the clerk's drop-down menu selection is merely an administrative label, so it's not a legally binding ruling. Okay, if there's ever a contradiction on the docket sheet, the law defers to the actual verbatim minutes of the court and then the sign orders of the judge. So in the Odyssey portal, where I saw this right here, it contains bulletproof proof that there was indeed a trial, and there was. So there was jury selection on February 2nd and 3rd. There was notes recording opening statements on February 4th and 6th when the trial was happening, which I mentioned before in previous stuff. And then there was on February 6th, there was also a docket that states, what happens. There was verdict forms that went along with that as well. And then on April 29th, 2026, the prosecutor returned to the court a file formal file that went along with it, and the judge can only file these specific postings and these findings if a finder of fact, so the jury or the court, entered a verdict. And then, so, as he's going along with this, obviously he may want to appeal because he has a good chance of being life in prison. I mean, he did think that he was soliciting a mom through a Craigslist ad so that he could SA an 11 and 13-year-olds. Yes. So as we're going through and do this, on that date, on that one right there where on the April 1st date where we had the error, the docket shows that Thomson was handed a notice of right to appeal. So at that moment, he was also given that as well. And when his public defender files the appeal with the Washington State Court of Appeals, they will request the entire trial transcript and the physical judgment and the sentence signed by the judge. It's Judge Rodriguez True. The appellate court will completely ignore the clerk's drop-down menu error because the signed sentencing order and the jury's signed verdict sheets are the supreme legal documents. So eventually, a supervisor in the Yakima County Clerk's office will likely spot this data error and then during a routine file audit and issue an administrative correction to change it. So it'll say guilty verdict by jury. And until then, it remains just a clerical blunder that's there in the Odyssey portal. So something I found as I was going through this case. So it's been a good case, though. We'll go and look a little bit more here into it. So as I do go back to the case right here, from the beginning, the case began. It actually originally began, going back and just kind of recapping some of the stuff that went along with this case, and we'll close it up here. Maybe unless we get an appeal down the road where it goes anywhere beyond him just staying in there. Or if he ever comes out, we may look at it again, but we're looking at 4 years down the road. So we may put this case to bed for 4 years, but thought I'd review it here in the next few minutes just to kind of give you a recap of what this was all about. So the case began on November 18th of 2019, and Fred was arrested, and he made his first appearance in court. And the charges that went along with this, so he was charged with 2 counts. Yes, 2 counts of attempted rape of a child in first degree, and then one of them, and then he was also attempted rape of a child in second degree. So those were the 2 counts. So attempted rape of a child in first degree, attempted rape of a child in second degree. And then initially, the initial judge was David A. Elofson, and he initially set his bail at $10,000. So he was appointed a public defender who was Lauren Oakley at the time. And then he was released on December of 2019, and his bail conditions were modified, and he was released on electronic monitoring. He had supervised release. He was a level B. He was later upgraded to a level C house arrest, and this was why he wasn't sitting in jail for the next 6 years. So there was a pretty big delay. So that was in 2019, and if you look from 2020 to 2025 before this case actually went to court. So it took a while. You may be asking, why did this take so long? Well, from early 2020 to late 2025, the case, was kind of an endless loop of these agreed continuances that went along. When I looked at the Odyssey portal, that was one of the things in there. And so during that time, this kicked off right before the COVID-19 pandemic, which heavily backlogged our courts. And then there was some illegal maneuvering that went along with that as well, too. They want to take advantage of this time. He got to be able to be out for 6 years. So there were multiple substitutions of counsel, so prosecutors were shifting around, and there was a critical CR 3.5 suppression hearing on April 25th, and a 3.5 hearing is where the defense tries to block the jury from hearing statements the defendant made to police. Okay, so during this time when he was probably Mirandized, and they're trying to decide, whether or not he was Mirandized yet or not, and so they wanted to know if the jury should be able to hear this or not, what he said. The judge ultimately entered the findings of fact and conclusions of this law on this, meaning the judge made the final ruling on what evidence was allowed. And then we hit the trial. So February 2026, this is back when I made a podcast on this. After years of delays, the court finally called a hard-set jury trial on February 2nd of 2026. And it was under Judge Sonia Rodriguez True. And then, like I had mentioned before, day 1 and day 2 were jury selection. Those were on February 2nd and 3rd. And they did private interviews with jurors regarding hardships on the days 3 and 4. There was opening statements and witness testimony, and the state presented its exhibits. On day 5 was the climax. The jury heard closing arguments. They deliberated, and they returned guilty verdicts on both count 1 and 2. Thomson was immediately taken into custody with a no bail hold. So it's kind of just a quick little recap of the case. And then from March to April, this is the stuff that happened in between the time when I recorded the podcast when we knew he was arrested to where we stand today. So on April 1st of 2026, the clerk, like I had mentioned before, accidentally selected a drop-down menu that reads case resolution guilty plea before trial commencement, which didn't happen. It was an error. The day-by-day notes explicitly prove that he went to a 4-day trial. I mentioned it all before. I gave all the details of that. That was all from the Odyssey portal, and a verdict was returned. And then under Washington state law, this is something that they're actually working to change. I need to go back and look and see where we're at with that bill from the west side of our state who's trying to change this law. But we have an exceptional sentence law. And under Washington state law, sex offenses involving children fall under special sentencing laws. So April 1st of 2026, Judge Rodriguez True handed down a massive sentence. And in the case of this one, the sentence was life in prison on both counts. So with a minimum term of 48 months, 4 years. And the docket notes a brutal stacking mechanism. So it states that counts 1 and 2 run concurrently for a 48-month minimum, but consecutively for the overall life tail. So and consecutive to any prior sentences he may have had. The final blow on this is that the prosecutors presented an order regarding exceptional sentence. And the exceptional sentence means the judge went outside the standard state sentencing guidelines to impose a harsher penalty backed up by formal facts. Taking a look at this right here. So in short, kind of wrapping this up, Thomson will go to prison for a minimum of 4 years, and before he's even eligible to have an indeterminate sentence review board and to consider releasing him. So the sentence carries a life tail, meaning the state can legally keep him under confinement or strict monitoring for the rest of his life. So, it's kind of how that goes right there, going along with that. So it's an interesting case because, it's something that I didn't really think happened. It's kind of cool in that way a little bit. That we just don't necessarily have, these things that happen like this very often. So wrapping this up, following his April 1st, 2026 sentencing, Thomson was transferred out of Yakima County Jail, and he's in custody with the Department of Corrections here. Because of his age, at 74 at his arrest, making him roughly 81 years old now, and the nature of his convictions, he was processed through the Washington Corrections Center in Shelton before being assigned to a long-term facility. Given his medical profile and the length of his sentence, he will spend his remaining years in high-security state facility equipped for aging inmates. So there we go, a retirement home for criminals. How wonderful. That's just nice that we have that for them. Going through with this as well. So the true closure in this case lies in how Washington handles sex offenses against children under its Indeterminate Sentencing Review Board, the ISRB. Thomson was handed down a life sentence with a 48-month term. This creates a definitive timeline. So he has a 4-year minimum. He must serve every day of those 48 months because he was credited with time served while he was on house arrest. That countdown is already moving, but he cannot be released standardly. And then the life tail of once those 4 years are up, he is not automatically released. Instead, his file goes before the Indeterminate Sentence Review Board. And then the board views him as a lifetime offender. So to ever be released, Thomson would have to prove he is completely rehabilitated and poses zero risk to safety. And for an octogenarian convicted on a calculated sting involving 2 young children, the likelihood of a board granting him release is virtually non-existent. So, I'm partly curious as to how long, like he got some, I didn't realize that part of it too, that he was served for being on house arrest. That's a unique one. So I wonder, I'm going to check into that here. Hold on. So taking a look here in the C. So, the question that goes along with this, specific entries, it started on December 5th, and this is the date that he was granted a bail motion, releasing him to electronic monitoring. So he's monitored then, and it was upgraded to house arrest. So on this day, the jury found him guilty. So he was out on house arrest for 6 years, 2 months, and 1 day. So the case dragged through the court system. That's interesting. I do want to know more about that. We may be looking at this more. So even though he wore an ankle monitor and was legally restricted to his house for over 6 years, Washington state law explicitly dictates that pretrial electronic home monitoring does not count as confinement for sentencing credit. So there we go. All right, so there we go. And this is actually a state that goes along with it. So under Washington case law, specifically State versus Swigger and related state statutes, time served credit is only granted for time spent in total confinement. So there we go. That's good to know. I wanted to make sure that was clear. Something wasn't right there. So meaning a physical jail cell or a state prison facility. Yeah, I wanted to make sure that wasn't counted. Because the defendant on house arrest still enjoys the comforts of home, can eat their own food, and isn't locked into a government cell, the state completely wipes those 6 years off the ledger. So yeah, there we go. That time it's not time served. Time served would have to be spent in a jail cell. And the docket explicitly notes that at the time of sentencing, April 1st, credit for time served determined by corrections. So the DOC will count only his days in a concrete cell. So he may have been in there, when he was arrested in November. The initial arrest happened November 16th of 2019 to December 5th to 2019. So roughly 19 days before posting bail. And then post-conviction, when he was on February 6th, 2026 to April 1st, he was in jail for 54 days in Yakima County. So instead of getting over 6 years, he shaved off 48 months of his sentence. He will only receive 73 days of actual jail credit. So that's good to know. And just some things. At 81 years old, he began serving his 4-year term with almost no credit, and he walked forward, so meaning he'll be 85 before the Indeterminate Sentencing Review Board even looks at his file for the first time. So good to know. Good to know that he will be in jail for a while. So I just wanted to provide you with that update. Be doing a few more cases here as I got some time, but that's one I was interested in the past, so I'll be hitting a few more later. I want to thank you for listening this far. Hope you're having a great day, and stay tuned for more podcasts.